I'm David Miller, and I've been practicing complex asset litigation and divorce law in California for 18 years. In that time, I've seen just about everything: greed, betrayal, desperation, and sometimes outright malice that makes your stomach churn. You think you know people, especially after 2 decades of marriage. But when millions of dollars are on the line, the masks can drop, revealing truly shocking depths. Imagine walking into court, confident in your client's position, armed with years of financial records, ready to secure a fair division of assets in what should have been a straightforward, albeit contentious, divorce. Then the opposing counsel, with a smug grin, presents what appear to be irrefutable documents, signed loan agreements, investment contracts, asset transfers, all allegedly executed years ago, dramatically altering the marital estate. Documents that, if legitimate, would strip your client of over half of what was rightfully theirs, leaving them financially devastated. My client Mark just stared, his face paling, as his ex-wife Sarah beamed triumphantly across the courtroom. It was a moment where the air crackled with tension and my heart hammered against my ribs. One shocking detail: the paper these critical documents were printed on hadn't even been invented when they were supposedly signed. At stake was not just Mark's multi-million-dollar fortune, but his entire future, his sense of justice, and his faith in the person he had loved for 25 years. Here in California, we operate under community property laws, which, in simple terms, means that any assets or debts acquired by either spouse during the marriage are considered community property and are generally subject to a 50-50 division upon divorce. This is enshrined in California Family Code, Tarf 25-5. However, it's not always that straightforward. Spouses also owe each other a fiduciary duty, similar to partners in a business, meaning they must act in the highest good faith and fair dealing with each other, especially concerning community assets. This is outlined in California Family Code, Paragraph 721B. Where things get complicated and frankly criminal is when one spouse breaches this duty through fraud or misrepresentation. California Family Code, Paragraph 1101, provides remedies for a spouse's breach of fiduciary duty, including the potential for a 100% award of an undisclosed or intentionally concealed asset to the innocent spouse. Furthermore, California Family Code, Paragraph 271, allows the court to impose sanctions on a party for engaging in conduct that frustrates the policy of the law to promote settlement and reduce litigation costs, which, as you can imagine, includes outright fraud. These laws are critical because they protect individuals like Mark from being exploited and ensure that the divorce process isn't just a free-for-all for unscrupulous partners. They provide the hammer needed to rectify severe wrongs, turning what might seem like a mere dispute into a fight against deliberate deception. Mark Peterson, a man in his mid-50s, was the kind of client who exuded quiet strength. He was a successful tech entrepreneur, brilliant in his field, but emotionally vulnerable when it came to his marriage. When he first walked into my office, his shoulders were slumped, his eyes shadowed by a grief that went beyond the end of a relationship. It was the grief of betrayal. He and his wife, Sarah, had been married for 25 years, a quarter-century love story that started with humble beginnings and grew alongside Mark's burgeoning career. Sarah, in her early 50s, was outwardly charming, a social butterfly who thrived on their affluent lifestyle. She had always managed the household finances, a role Mark, busy building his company, had implicitly trusted her with. The turning point came in late 2018 when Mark successfully sold his tech startup for a staggering $20 million. This was the culmination of 2 decades of grueling work, countless sleepless nights, and immense personal sacrifice. The plan was to enjoy their wealth, perhaps travel, and finally relax. But instead, the money seemed to amplify the cracks in their relationship. Sarah, Mark explained, became increasingly distant, cold even, yet aggressively possessive of the new wealth. She started making extravagant purchases without consulting him, began talking about her inheritance, and pushed him to sign off on various investments and asset transfers she claimed were for tax purposes. Mark, trying to salvage their marriage, often acquiesced, wanting peace. By late 2021, Mark couldn't take it anymore. The emotional distance was too great, the control too suffocating. He filed for divorce. That's when Sarah's true colors began to show. Her initial demands were outrageous. She wanted the Malibu mansion, the Tahoe cabin, a multi-million-dollar support package, and half of virtually every other asset, even attempting to claim portions of Mark's premarital separate property. Mark was prepared for a fight over the community property, anticipating a 50-50 split of the $20 million from the sale of the company, plus other assets. But what came next blindsided him. During the discovery phase, Sarah's attorney produced a trove of documents, a loan agreement from July 14, 2017, showing Mark had supposedly borrowed $5 million from Sarah's elderly aunt, which was now classified as Sarah's separate property debt that needed to be repaid from Mark's share. Investment contracts from early 2018, allegedly signed by Mark, divesting large portions of his company stock to various shell entities, effectively reducing the community property value of his company by millions before the sale. A series of gift deeds from 2019, indicating Mark had gifted several high-value assets, including a prized antique car and a substantial art collection, to Sarah's family. Mark swore he had never seen, let alone signed any of these documents. He remembered vaguely discussing some tax planning with Sarah and signing a stack of papers she presented, but he trusted her completely at the time. "David," he'd said, his voice raw, "I felt like I'd been punched in the gut. I put my life into that company, into our marriage. Now she's trying to steal it all, and she's got these official-looking documents. Am I going crazy?" His vulnerability, his genuine shock, and the sheer audacity of Sarah's claims convinced me. I saw a good man being preyed upon, and a profound injustice about to occur. This wasn't just about money. It was about integrity, trust, and setting a precedent. I took the case knowing it would be a messy fight. My initial review of Sarah's evidence against Mark's meticulously kept business records and bank statements immediately raised red flags. There were simply too many inconsistencies. Mark's financial records showed no trace of a $5 million incoming loan, nor any outgoing payments to Sarah's aunt. The investment contracts were vaguely worded, and the entities listed were obscure with no clear business purpose. The gift deeds seemed to appear out of thin air. It all felt too perfectly orchestrated, too convenient, and crucially too late in coming forward. This wasn't a case of mere memory discrepancies. It was a case of deliberate obfuscation. I knew we needed to bring in the big guns. First, I retained Elizabeth Chen, a sharp-as-a-tack forensic accountant. Her job was to dive deep into every financial transaction, every ledger entry, both Mark's and Sarah's, searching for any whisper of truth in Sarah's claims, or more likely, signs of fabrication. She quickly noted discrepancies in Sarah's personal ledger entries, an unusual lack of supporting bank transfers for the alleged loan, and a suspicious pattern of cash withdrawals from joint accounts that vanished into thin air. Next, I brought in Frank Rizzo, a private investigator known for his discreet but relentless pursuit of facts. I tasked him with digging into Sarah's activities, particularly around the dates mentioned in the suspicious documents. We wanted to know who she was meeting, what new ventures she was pursuing, and any unusual financial behavior. Frank uncovered a hidden P.O. box in a different city that Sarah had opened shortly after Mark filed for divorce, and traced an anonymous LLC, limited liability company, registered to a relative of Sarah, an entity that suspiciously matched one of the investment shell companies. The most critical expert, however, was Dr. Eleanor Vance, a certified forensic document examiner. I handed her the original loan agreement, the investment contracts, and the gift deeds. Her mission? Analyze the paper, the ink, the typeface, and most importantly, the signatures. The investigation was a slow burn, fraught with tension. Opposing counsel, Gloria Albright, a formidable shark known for her aggressive tactics and seemingly unblemished winning record, was dismissive. She constantly filed motions to limit discovery, citing privacy concerns and painting Mark as a vindictive ex-husband trying to avoid his marital obligations. "Mr. Miller," she'd sneer during phone calls, "your client is simply in denial. These documents are irrefutable. You're wasting everyone's time and money." Sarah, during her deposition, played the part of the confused, aggrieved wife, claiming Mark had simply forgotten these transactions. She swore under oath that everything was legitimate. Her performance was almost convincing, almost. But we weren't done. Elizabeth Chen found that several large deposits into Sarah's newly opened personal account, around the time of the alleged loan repayment from Mark, came from a series of small, untraceable cash deposits, not a single lump sum from Mark. Frank Rizzo's surveillance revealed Sarah making frequent, clandestine visits to a print shop known for specialized document services, often carrying large envelopes. He also managed to get photos of her entering the P.O. box, which had been set up under a false business name connected to the Shell LLC. The turning point came with Dr. Vance's initial findings. She noted unusual ink density variations in Mark's purported signatures on the investment contracts, suggesting tracing. The paper stock of the loan agreement and gift deeds felt unusually stiff and slightly discolored, despite being presented as aged. Dr. Vance explained that paper ages naturally in specific ways, and this didn't match. We were getting close, but we needed the smoking gun. The breakthrough moment arrived on a Tuesday afternoon. Dr. Vance called me, her voice calm but with an undeniable edge of excitement. "David," she said, "I have the definitive proof on that $5 million loan agreement." My heart raced as she explained. She had conducted a thorough spectral analysis on the paper itself, a non-destructive method that allows for precise dating of materials. The paper stock used for the alleged July 14, 2017 loan agreement, Mr. Miller, she stated, was manufactured by Terra Firma paper mills using a unique blend of recycled fibers and a proprietary polymer coating. My research, cross-referenced with Terra Firma's own production records and industry supply chains, unequivocally shows that this specific paper stock was not commercially available until January 2019 too. The words hit me like a physical blow, yet brought an incredible surge of adrenaline. It wasn't just a discrepancy, it was an outright undeniable fabrication. The document, purportedly signed in mid-2017, was printed on paper that didn't exist until 18 months later. This was the smoking gun. This piece of evidence was legally significant because it moved beyond a he said, she said scenario into irrefutable scientific proof of fraud. It wasn't just Sarah lying. It was concrete, physical evidence that she had forged documents to defraud the court and my client. It fundamentally shifted the entire dynamic of the case from a property dispute to one of criminal deception. I called Mark immediately. I could hear the worry in his voice before I even spoke. "Mark," I said, trying to keep my own voice level, "we've got her. The loan agreement. The paper it's on wasn't manufactured until 2 years after. It was supposedly signed." There was a long silence on the other end, then a shaky breath. She really did it," he whispered, a mix of disbelief, fury, and immense relief in his voice. "She actually faked it all." I could hear him wiping away tears. "Thank you, David. Thank you for believing me. The path ahead was clear. We were going to expose Sarah's scheme in open court, and she was going to lose everything she tried to steal." The San Francisco Superior Court, Department 13, felt charged with an almost palpable tension that morning. Judge Evelyn Hayes presided, a woman known for her sharp intellect, unwavering fairness, and an absolute intolerance for dishonesty in her courtroom. Gloria Albright, Sarah's attorney, still carried herself with an air of practiced confidence, but I detected a subtle unease in her movements as she greeted me. She knew we had something, but she couldn't know the full extent. Sarah, dressed impeccably, maintained a veneer of composure, occasionally sending a saccharine smile across the aisle to Mark, who sat beside me. His jaw set. Our strategy was to present the scientific evidence first, laying an undeniable foundation before we cross-examined Sarah. My key witness was Dr. Eleanor Vance. Dr. Vance, calm and professional, walked the court through her process, explaining spectral analysis, paper dating, and ink examination with the precision of a seasoned academic. She presented enlarged photographs of the loan agreement, pointing out the unique watermark and fiber composition of the paper. "And based on your extensive analysis, Dr. Vance," I asked, "what is your expert opinion regarding the date of manufacture of the paper used in Exhibit A, the alleged July 14, 2017 loan agreement?" She paused, looking directly at the judge. "Based on meticulous research of industry records and Terra Firma paper mills production logs, it is my unequivocal opinion that the paper stock utilized for Exhibit A was not manufactured until January 2019. At the earliest, a ripple of murmurs went through the gallery. Judge Hayes, ever stoic, simply noted the testimony. Gloria Albright's cross-examination of Dr. Vance was aggressive. "Dr. Vance," she began, "are you suggesting that my client, a respected member of this community, would stoop to forging documents, Isn't it possible there was a batch of this paper available earlier? Perhaps an experimental run? Dr. Vance remained unperturbed. Ms. Albright, my analysis is based on scientific fact, not conjecture. Terra Firma's records are exhaustive. There were no experimental runs of this specific proprietary stock prior to its commercial release. To suggest otherwise would be to defy the manufacturer's own detailed logs and industry-wide distribution data. She held her ground, her credibility unshakable. Then came my cross-examination of Sarah Peterson. This was the moment of truth. She had already testified under direct examination that she personally witnessed the signing of the $5 million loan agreement on July 14, 2017, and that Mark had signed the investment contracts in early 2018. She maintained her innocent facade. Ms. Peterson, I began, my voice even. You testified under oath that you were present when your aunt signed the loan agreement with Mr. Peterson on July 14, 2017, correct? Sarah, with a confident, almost condescending smile, replied, Yes, that's correct. I remember it clearly. It was a stressful time for my aunt, and you personally held the document, observed its printing and signing. I pressed. Of course, she said, her head held high. I ensured all details were handled properly, and you would recognize the paper, the specific feel of it, if you were to see it again. She hesitated for a fraction of a second. I suppose so. It was just standard paper. Let's be very clear about standard paper, Ms. Peterson, I said, a controlled intensity in my voice. Judge, I request permission to approach the witness with Exhibit 47, Dr. Vance's full report. Permission granted. I placed the report and the enlarged photographs of the paper's fiber composition directly in front of Sarah. Ms. Peterson, I continued, you unequivocally stated that you witnessed this loan agreement being signed on July 14, 2017. Can you explain to this court how you could have witnessed a document signed on paper that, according to the scientific evidence presented by Dr. Vance, was not commercially manufactured or available anywhere in the world until January 2019? No. The courtroom went utterly silent. You could literally hear a pin drop. Sarah's confident smile faltered, then drained completely from her face. Her eyes darted to Gloria Albright, who now looked absolutely furious, a vein throbbing in her temple. Sarah stammered, her voice a reedy whisper. I don't understand. That's impossible. I clearly remember it. Her composure shattered. She began to fidget, her eyes wide with a dawning horror. Judge Hayes leaned forward, her gaze piercing Sarah. Miss Peterson, she said, her voice cutting through the thick silence like a knife. Do you have any explanation for how you witnessed a document signed on paper that literally did not exist yet? Nearly 18 months before its first production run? Sarah's face was now a mask of pure terror. She mumbled something incoherent, shaking her head, tears starting to well up. Her entire carefully constructed facade crumbled before everyone's eyes. Gloria Albright quickly requested a recess, her face a mixture of defeat and thinly veiled disgust. The climax had arrived and Sarah was caught, red-handed. After an agonizingly long recess, Judge Hayes returned to the bench, her expression grim. She had clearly reviewed Dr. Vance's report and the implications of Sarah's testimony. Her ruling was swift and decisive. She found clear and convincing evidence that Sarah Peterson had deliberately engaged in fraud upon the court by fabricating and presenting forged documents, specifically the loan agreement and investment contracts, with the intent to deceive and defraud Mark Peterson of community property. The outcome was devastating for Sarah. Under California Family Code Per of 1101H, the judge awarded Mark 100% of the community property that Sarah had attempted to conceal or diminish through her fraudulent scheme. This meant the $5 million loan amount, plus the full value of the divested company stock, was awarded entirely to Mark. This significantly increased Mark's share of the marital estate, effectively reversing all of Sarah's attempts to manipulate the division. Furthermore, Judge Hayes did not hesitate to impose severe sanctions under California Family Code, paragraph 271. Sarah was ordered to pay all of Mark's legal fees and expert costs, amounting to over $500,000, as a direct consequence of her bad faith litigation tactics and deliberate fraud. But the consequences didn't end there. In a rare and powerful move, Judge Hayes referred the entire matter to the San Francisco District Attorney's Office for potential criminal charges, including perjury and fraud. Sarah's attempt to steal had not only backfired spectacularly in civil court, but now threatened her with criminal prosecution. Mark's reaction was one of profound, quiet victory. In the hallway, he hugged me tightly, tears streaming down his face. "Justice," he whispered. "I just wanted justice." His financial future, once jeopardized, was not only secure, but better than it would have been if the divorce had proceeded fairly before the fraud. The woman who sought to strip him bare was now facing the consequences of her own desperate greed. In the months that followed, Sarah Peterson faced a grueling criminal investigation. To avoid a lengthy and embarrassing public trial, she eventually pleaded no contest to a lesser charge of attempted grand theft and perjury. She received a significant period of probation, a substantial fine, and her reputation was irrevocably tarnished. The lavish life she had planned for herself, financed by deceit, evaporated. This case, Peterson versus Peterson, taught me several profound lessons. Firstly, it reinforced the critical importance of never taking anything at face value, especially when significant assets are involved. The human capacity for deception, fueled by desperation or greed, can be truly astonishing. Every document, every claim, must be meticulously scrutinized. The broader legal lesson here is clear. The legal system, while often slow and frustrating, does have mechanisms to uncover and punish fraud. Fiduciary duties in marriage are not mere suggestions. They are legally binding obligations, and breaching them through deliberate deceit, particularly fraud upon the court, carries severe consequences. Attempting to manipulate the system with forged documents is a high-stakes gamble that rarely pays off when up against thorough investigation. For anyone watching, here are the warning signs you should absolutely watch for in your own relationships, especially if divorce might be on the horizon. Sudden secrecy in finances. If your spouse suddenly becomes cagey about money, takes over all financial management, or refuses to provide transparency on accounts. Unusual debts or investments. If you hear about new loans, obscure investments, or gifts that you have no recollection of. Overly perfect or missing documents. Be wary of records that seem too pristine, lack typical banking trails, or if key documents seem to disappear. Push to sign without review. If you're frequently asked to sign stacks of papers without explanation, trust your gut and read everything. My practical advice is this. Keep meticulous records of all your financial dealings, even within a marriage. If you're facing a divorce and something feels off about your spouse's financial disclosures, trust that instinct. Don't hesitate to hire an attorney who is not afraid to dig deep and involve forensic experts. Trying to save money by avoiding thorough investigation can cost you millions in the long run. Professional insight tells me that desperation can drive people to unimaginable acts. But truth, aided by diligent legal work, has an uncanny way of surfacing. Today, Mark Peterson is living a life far removed from the courtroom drama. He's found peace, re-engaged with his passions, traveling, and has become a quiet but significant supporter of charities that aid victims of financial abuse. He's a testament to resilience and the ultimate triumph of justice. Cases like Mark's are why I do what I do. It's not just about winning. It's about fighting for what's right, protecting the wronged, and ensuring that the legal system, with all its complexities, ultimately serves justice. It's about giving a voice back to those who thought they had lost everything. Drop your questions about this case or any similar situations you've encountered in the comments below. I'm always interested in hearing your thoughts. And trust me, I've got plenty more stories to tell, where the truth was stranger than fiction, and justice ultimately prevailed. Stay tuned.